Level of proof refers to the evidence that must be presented to establish the occurrence of an event. As per rules of evidence followed by the courts, there are different proof requirements, such as beyond reasonable doubt, used mostly in criminal trials, and balance of probabilities as the standard which is used in civil cases. Human rights organizations may not be able to achieve a high level of proof because of a number of reasons, such as they do not have the power to compel testimony or the production of documents, or they do not have the power to impose penalties for withholding evidence. Despite these constraints, human rights organizations should strive to obtain as high level of proof as it is possible in a given circumstances. Commonly, human rights organizations use the standard of balance of probabilities, which means considering the evidence, the occurrence of an event was more likely than not. Now, what level of proof should human rights monitors strive for? The level of proof required depends on the action that the organization intends to take on the case and the audience of the report. With regard to action that the organization intends to take on a case, for example, if the objective is to send a mere letter of concern to the authorities, then such letter may be based on credible second-hand reports about the alleged violation. On the other hand, if the organization intends to publish a human rights report, then more substantial evidence is required to arrive at a reasonably founded conclusion. Depending on the circumstances surrounding the case, the organization would have to decide the level of proof that they can realistically achieve and then decide upon the course of their action. Otherwise, the fact finding activity can become a never ending process. Another consideration is the audience of the report. When the context of the violation is such that the concerned government will most probably contest the finding of the human rights organization and attempt to discredit it by finding false, then in such cases the level of proof must be very high. A fact finder should disclose the level of evidence in the report. Incidents the veracity of which cannot be 100% established can be included in a report as long as the level of probability of their incidence is disclosed. For example, if there is not enough evidence to definitely conclude, the case can still be presented as very likely or probable or eyewitnesses stated that, and so on. The report should state the standard of proof employed by the fact finder. Burden of proof. A primary purpose of human rights investigation is to find the truth, or the nearest thing to it, and present it in such a way as to shift the burden of proof to the government so as to oblige it to take action on it. At each step, the evidence has to be enough to shift the burden back to the government. What is enough can vary. Most often, governments tend to deny findings made by human rights organizations. However, human rights organizations, by persistently publishing credible reports, often succeed in forcing the governments to at least indirectly acknowledge the findings. This is called admissions against interest. It refers to statements that acknowledge or reveal incriminating information. Now let's do an activity to review the concepts learned so far. Two examples are presented to you, each followed by a question that you need to analyze. You can check your understanding after you have finished the analysis. In the first example, you find the excerpt from a 1993 annual report on human rights in Nigeria by the Civil Liberties Organization. In the excerpt, the police officer is acknowledging that torture is used to gather information from suspects. The question is the state condoning the practice of torture? What do you think? So, in your review, did you note that the police officer is acknowledging that torture is used to gather information from suspects? However, such statements should not be interpreted only in the negative sense. The officer is also articulating a reason as to why the may resort to torture tactic, which is to get information from suspects. This revelation can help in identifying measures that can be taken to eliminate the use of torture, such as training police with better investigative techniques so that they do not have to resort to torture. The state is acknowledging the fact of detention in overcrowded conditions. However, again, such statements should not be interpreted only in the negative sense. The admission by the government can open up the space to discuss measures that can be taken to ease the overcrowding in detention centers. Thus, admissions against interests become possible through credible and systematic reporting by human rights organizations. Such admissions are helpful in starting a process of constructive dialogue with governments about actions that can be taken by them to strengthen the protection of rights. Finally, there must be consistency in the level of proof adopted from report to report, unless there is a good reason to change. For example, if a particular form of action is described as ill treatment in one report, it should not be changed to torture in later reports without giving reasons. Or, in other words, based on the definition of ill treatment in the Convention Against Torture, there are certain elements that constitute ill treatment. Now, one must find proof of those elements in order to call that action ill treatment. Apply the standard of proof across all reports. Do not suddenly switch to calling the action consisting of the same elements as torture.